Hello, I'm attorney Thomas Burton. I'm an estate planning and asset protection attorney here in Wisconsin. And today I want to continue my estate planning 101 tutorial series. And this is today's topic, will or trust, what's the difference? So I see this question come up a lot in my estate planning practice, and I wanted to create a little longer form tutorial video walking you through the differences between these two types of plans here in the state of Wisconsin. So I'm going to use my trusty yellow legal pad and walk you through it just as a way of sort of organizing my thoughts visually for you as we go through it today. Okay, so first of all, you'll see under a trust, if you form a trust plan, you're going to name a trustee. That's the person in charge of taking care of your assets in the trust. So during lifetime, the trustee will often be yourself. If it's a revocable living trust, you and your spouse, or if you're married, or just you, will be the primary trustee. So that's number one. Then after you're gone, so think about after your death, we have a successor. And that person administers the estate after you're gone. Now, if we go over here to a will plan, instead of a trustee, we have what's called in Wisconsin a personal representative. Now, some states call this person the executor. So if you hear I need to name an executor under my will, just be aware in Wisconsin we call them a personal representative, and it means the same thing. But unlike a trust, they only take over after you're gone. So only after death, okay? This person would begin to act on your behalf, and they would again be, you can name a primary, and I recommend naming a successor just in case something happened to your primary. Now you can name as many as you want, but I always recommend at least two if you're going to go through the time and expense of putting together either a will or a trust. I recommend having at least one backup to whoever you name as the primary. Now, an advantage to the trust plan is that the trustee begins serving as soon as you form the trust, meaning during life, and that again can be yourselves or you as the trustee and then a successor, and you can also name another backup. We can name as many backups as you like under each plan. But that's key to have in your mind the difference. So if you hear the word trustee, that's under a trust plan, and if you hear the word personal representative, we're going to be talking about a will plan, okay? So now let's turn to the next topic of the difference between the trust and the will. So the big difference, there's lots of differences, but I'm going to cover the highlights today. Trust is a private document during life. It's a private contract between you and your trustee. And a will is private during your life, but after your death, by statute, it must be filed with the probate court, okay? So after you die, everything becomes public that's inside the will. So that's a big difference. One is private administration, and the other is public administration by definition, okay? So if you have a trust plan, the goal is to avoid public court process, and if you have a will plan, by statute, by law, it must go through the probate court process. So if there's anything in your estate planning documents that you want to keep more private, consider doing that inside a trust plan, because a will is going to get filed with the probate court after death. In fact, there's statutes that your personal representative must present it. So that brings us to the next difference. A trust, we set up the assets in there to avoid probate. So if you go through the time and expense of setting up a trust plan, the goal is to avoid probate upon your death. A will plan, by definition, must go through probate. So I see a lot of confusion about this. You can't set up a will plan to avoid probate, okay? If you're setting up a will plan, your plan is to go through probate. So there's other ways to plan to avoid probate, but just forming a will is not enough. And I've got a handout on this, if you want a copy from my office, I talk about 3 plans for your estate. No plan, meaning nothing in writing at all. Will plan, which is a probate, to go through probate, and then a trust plan, which would be to avoid probate. No plan, will plan, trust plan. So the goal, if you do the trust planning, is to have no fees on the assets passing under the trust, because they're not going through the government probate court system. There's no separate fees on the total assets, okay? So that's, if you're doing trust planning with my office or another estate planning attorney, they generally cost a little more upfront to set up, okay? But the goal is to avoid probate and save all that money in probate court fees. So if you work with my office, you'll hear me say, if we set up your trust plan, my goal is to have all your assets pass under the trust so you don't end up paying any probate court fees, okay? So in Wisconsin, there's probate court fees assessed on all the assets passing under the will. So if you think about everything in your house, the personal property, the value of your house, less any liens, cars, vehicles, boats, it's all, your personal representative has to come up with a reasonable fair market value and list it. And then the fees are $200 for every $100,000 in value. So in Wisconsin, the fees are not as terrible as some states like California, but the more you have passing in a probate, they add up. So if you think about $500,000 a probate estate, it'd be a $1,000 inventory filing fee. And that's just the fee to open the estate, okay? That's just the check you write to the probate court to open the administration. There's more fees, including attorney fees. Most people, if they haven't done a probate professionally before, they'll end up hiring an attorney. So if you do a probate plan to spend 3 to 6% of the net assets on all the total fees, okay? Probate court fees, attorney's fees, tax filing fees, etc. So you can see that as you have more assets, the fees under a will go up, and then you're gaining even more value from avoiding probate over here, not to mention the stress, paperwork, and time delay. So under a will plan, I don't have this written, but statutorily 6 months is the shortest probate, 6 months, and a trust 6 months to 2 years. In a trust plan, I tell people on average, you, depending how ambitious your trustee is and what, if you have to sell real estate, etc., you could have it wrapped up in 6 months or 1 year for sure, all done, and then you only file one tax return. Okay, so moving on, I got off a little bit on extra content there. The other big difference about a trustee under a will, a trust, and a personal representative under a will. Trustees' fees under your trust, you can set the fee yourself. We often use language saying a reasonable fee, but we can also write in exactly what you want to pay them. For example, if it's a child or something and you just want to put a certain dollar amount, put that right in there. Under a will, the personal representative's fee is 2% of the net assets, and that's set by statute. So again, as your estate gets larger, this fee can be quite significant, and it doesn't always mean there's that much work. For instance, some estates with $1 million have a lot of work. Others, let's say it's $1 million in bonds. If you have that flow through your will, that isn't necessarily very much work, but your personal representative would still get $20,000 for being the personal representative. So in that instance, I'm not sure, that you need that 2% is equivalent to the reasonable value of the work, right? So think about that, talk to your attorney, because you can get, in some ways, a better deal on trustee fees under your trust. And in general, corporate trustees like a bank or a trust company, they charge 1 to 2% of assets. And this fee the scale goes down as you have more assets. So I've seen these fee schedules from the banks, and generally there's a fee on the first 500,000 or $1 million, and then it goes down from there. So let's say you had $2 million in bonds, you would pay that 2% $40,000 to your personal representative, whereas over here it might be 1% or less because that sliding scale as it goes up. So the more assets you get too, in my opinion, you could get a better service and better fees under a trust plan. So just be aware, under a trust we can set up whatever fees you want to pay your trustee. It's up to you. Under a will, it's by statute, and that's here in 857.05. You can find it if you just Google it. It's 2% if you see at the bottom there. I'm not the best at moving my pen with this. 2% of the net fees. So net means less any debts like a mortgage on real estate. So that's a key difference between a trust plan and a will plan, the fees you pay the trustee versus the fees you pay your personal representative. So today I wanted to go over some of the differences, the key differences, big differences between a trust plan and a will plan in Wisconsin, and specifically some of these key terms I see come up, like trustee versus personal representative. So as you're thinking about your own estate plan, you can decide which one makes the most sense for you. So this is another part in our estate planning educational series, Estate Planning 101 I call it. And I hope you find this video helpful to you. Now, if you're interested, earlier I mentioned that No Plan, Will Plan, Trust Plan brochure. Get in touch with the office. You can email me. Be happy to send you a copy of that. And also, if you've seen any of my other videos, I have a will versus trust one-page guide. It's available from my office on my website, and I'll put a link on YouTube to that guide in this video. That one you can just enter your email and it'll be sent to you immediately. So stay tuned for more in our Estate Planning 101 educational series. Thanks for watching, and we'll see you next time.